Thank you so much for being here. I would like to first thank the organizer for making this event possible. So the panel that we have organized revolves around questions pertaining to Islamic law, legal theory, and questions of authority. The first presenter is Sara Omar. She's assistant professor of Arabic and Islamic Studies at Georgetown University. Prior to that, she was a postdoctoral fellow at Yale. And she's going to talk about the logic of legal reasoning contesting Liwāṭ punishments. Thank you, please.
Thank you.
Yeah.
So I'd like to start by thanking the organizers. Thank you so much for putting this wonderful workshop together. I'd like to especially thank Dr. Amin Ehteshámi for inviting me. And I want to start by addressing what some of you might be thinking as you're looking at the topic of my talk, which may raise some questions as to what is Liwāṭ doing on a panel of Islamic philosophy. Amin had wrote in sort of the description of this panel that it seeks to explore the textual evidence for the ways in which Muslim jurists debated theological and philosophical matters in their texts. So my paper today examines the logic of legal reasoning behind legal disputes over the punishment of those who engage in Liwāṭ, which is male-male anal intercourse. And this is the only time I'll define it. You just have to keep that in the back of your mind if you don't know the Arabic term. But Liwāṭ is neither is neither a philosophical nor a theological question. However, at least in the early period, as of the 11th century, the language of natural philosophy ends up shaping certain definitions of Liwāṭ, but this is only a later development. During the 4 centuries after the Prophet's death, it was viewed as a legal question, a sin worthy of had punishment, a capital offense, viewed as a capital offense by some. As such, it did require jurists to offer textual evidence or some form of legal reasoning to support their competing legal positions. I'd like to position my talk within my larger book project just to give you a sense of where this fits in. The larger book project focuses on the period up to the 10th century. In the talk today, however, I'll start at a later period and work my way backwards in time. I do this in order to challenge us to reconsider our own assumptions about the nature of texts and time. Sorry, I'm so used to using my own laptop. Okay. Dr. Muhammad Ghariba reminded us in his opening remarks yesterday that texts are not static entities. And while I'm sure all of us would nod in agreement with this and would actually acknowledge the variance in Muslim scholars' ideologies, I think we tend to forget the variability in scholars' methods and legal reasoning. So I put 2 questions on this slide that I've thought about a lot for my book, or my current book project. The first question, which is at the heart of this talk, is what happens when we read later texts to reconstruct earlier texts and earlier discourses? I'm certain that all of us are guilty of this to varying extents. I know I myself am. When we read texts of a particular period as somehow representative of all periods, we produce an entirely new text, which is not necessarily historically tenable, and I'll give an example in a bit to illustrate this. This text also comes to represent a fixed Islam, which is contrary to the Islam that most of us as academics tend to teach and educate our students in, right? We tend to teach an Islam that is changing and malleable, constantly shifting and evolving in accordance to historical contexts and geographical distinctions. The second question, which I will not get into today, but I still feel the need to at the very least raise, is what happens when we only read one type of text, right? If we focus on theology or law or philosophy or tafsir, hadith, etc. When we do this, we end up with only one piece of the larger puzzle, rather than a whole image or the whole image. And here I'm reminded of Mark Bloch's caution where he says, quote, "Each science taken by itself represents but a fragment of the universal march towards knowledge," end of quote. So in my larger project, I therefore tried to look at a wide range of genres as interconnected discourses in order to appreciate the social meanings produced by these texts and the discursive processes that produce them. What I hope to accomplish today is to illustrate Muslim jurists' varying logic of legal reasoning as they adjudicated Liwāṭ over a substantial period of time. My goal is for us to begin to appreciate the way in which Muslim discourses have shifted and changed over time. The implication of this, of course, is that just as discourses have shifted over time, so too are they shifting in time. So let me turn to the example I promised to offer earlier. The 14th century Hanbali jurist, who does not need an introduction, Ibn Taymiyyah, wrote in the 14th century and appeals to the companions' consensus, the ijma' of the companions, the ijma' of the Sahaba, while making a case for an unconditional death penalty as the appropriate punishment for those who engage in Liwāṭ. He was not the first to do this, of course. Abu Ya'la al-Farra had made a similar claim 3 centuries before him, as well as a number of others. So as we shall see shortly, there is no evidence that such a companion consensus ever existed in this regard. While some later jurists claimed a purported companion consensus on execution, others underscored the various disagreements amongst the companions. For example, the Hanafi jurist al-Qaduri made the opposite claim roughly around the same time period. Not only was there no companion consensus on whether to punish males who engage in Liwāṭ through the hadd of execution, be it conditionally or unconditionally, and I'll explain this in a moment, but more importantly, the sources of the 3rd and 4th centuries Hijri show that the companions, successors, and some of the early jurists are personally attributed with holding conflicting legal opinions on this issue. So why then would these jurists appeal to companions' ijma' when no such companion ijma' existed in this regard? One answer could be that this claim invests their doctrinal positions with the authority of the companions. But in the process of making this claim to companion consensus, jurists created what I'm calling a new text, which continues to be cited until today. So I'm hoping to complicate this picture by showing how this new text, right, this claim to companion consensus, created prior to Ibn Taymiyyah, roughly around the 10th century, is indeed historically untenable. It should be noted that from very early on, Muslim jurists were debating the forms of punishment for this offense. Meaning, and this is where an explanation might be helpful, should offenders be punished with an unconditional death penalty through stoning or a conditional death penalty based on the zina model of punishment, i.e. based on one's status of ihsan or non-ihsan? And so what you'll find is the two on the left are the capital punishments that were perceived as appropriate for the offenders. And there were debates as to the forms that these should take. The unconditional death penalty was seen as one that should be applied through various means, through stoning, death by the sword, burning, collapsing a wall over the person, throwing a person off of or shoving a person off of a structure, while the head of a conditional death penalty, and these are all sort of my ways of pitching these different punishments, was based on the zina model. Again, if you're muhsan or non-muhsan, you're either punished with stoning or flogging. And then you get debates of the use of ta'zir, which is discretionary punishment, and these take different forms: imprisonment until death or repentance, and you get other forms as well. And then this is a much later suggestion, which is to punish it through a siyasa punishment. You find this with Ibn al-Humam in the 14th century, and you get a different way of justifying the punishment for this offense. Okay, so this is sort of the early discourses besides the siyasa punishment, ta'zir and the two types of hadd. These are earlier. Later, we end up beginning to see appeals to the logic behind the gradation of punishment. That is this offense worthy of a capital punishment, a hadd? Is it worthy of ta'zir, or is it worthy of legal expediency, siyasa? So you get two types of discourses that are happening. The earlier is focused on forms of punishment. The later is focused on justifying these forms of punishment through these different, three different categories of punishment. If we trace the development of jurists' textual evidence or the legal logic behind their legal reasoning to support their legal punishments for one of the competing positions in this debate, what we notice is that jurists invoke different authoritative sources to make different appeals to legal tools depending on the time period under examination. So I've split it by periods, and these are sort of trends that I've observed in my own studies of this topic. What you find is up until the 9th century, there's an appeal to this concept of sunnah madiyah, or some use of different sunan. As of the 10th century, you end up having an additional appeal to prophetic hadiths. Late 4th, early 5th centuries, you have appeals to qiyas. And then 5th, 11th century, you end up having claims of companion consensus, which we've seen, I've touched on a bit, but it isn't going to be the main focus of this topic, of this talk. So starting with the earlier centuries, and I'll make my way through these different periods, what you find is that the concept of sunnah has a history where its meaning and application changed over time, right? All of these concepts are historical concepts, they change, they evolve. There are arguably 3 phases of development that the concept of sunnah underwent. The first is sunnah, meaning the practice and traditions of ancient Arabs, Jews, and Christians. At least this is the pitch I'm making. The second is sunnah encompassing or being encompassed within a broader notion of sunnah madiyah or sunan madiyah, meaning the practices and traditions of all of these communities in addition to those of the Prophet, his companions, and the successors. And then sunnah as exclusive to the Prophet Muhammad, whose precedent came to serve as model behavior. It should be noted that while both the conditional and unconditional death penalties were legal positions that existed from very early on, there are noticeable regional differences, which can be traced to differing legal precedents and sunan. The Malikis, or the Madani's position, they are the only ones who adopted the had of unconditional execution through stoning, at least as the main predominant mashhur opinion of that, what became that madhab, while the Kufans, Basrans, and others debated whether it should be the had of zina or no had at all. These positions can be traced to punishments that predate Islam, including the Madani's punishment of unconditional execution through stoning, which can be traced back to the Jewish legal precedent, which some of you touched on in your talks yesterday. I do this for other parts of the book, but this is the legal precedent that I focus on for this talk is here. And so what you find is the Jewish legal precedent, and I'm only giving a very brief overview. I go in much more detail in the actual chapter. But what you find is that Liwāṭ was viewed, or male-male anal sex in the Jewish tradition was viewed as an abomination. The word in the Hebrew is to'avah, which is the equivalent to fahisha for those of you who know the Arabic. And so what you find is repeated reference to fahisha, or a repeated reference to to'avah in Hebrew. And you also find that there's a suggested, recommended, they shall be put to death in Leviticus, right? That there's an actual suggestion of that it is a capital offense, it should be punished through death. Interestingly, when you look at the Mishnah, what you find is a description of what that death should look like, right? I try to minimize the wording here, but in the end, the punishment is stoning, and the form of stoning that it takes is the offender's taken off to a cliff. They're pushed off of the cliff, and if they're not dead, there's a whole procedure. It's very detailed. But if they're not dead, then it's followed by stone casting in some sequence. Interestingly, what you find is in the Muslim tradition, there are plenty of hadiths and reports that tell us that Ibn Abbas, in addition to Az-Zuhri and others, who have made a very similar claim to the type of punishment that should be carried out. So it should be unconditional death penalty through stoning, and the stoning is indeed the same or very similar to that which is outlined in the Mishnah, right? So Ibn Abbas was asked, what is the had of a luti, the one who commits liwāṭ? And he replied, he should be taken to a structure in town and thrown off of it head first, followed by stone casting. The Kufan and Basran positions punishing liwāṭ conditionally, like zina, can be traced back to Roman legal precedent. Not long after the Roman Empire became Christian in 313 CE, the crime of male-male anal intercourse was punishable with burning. Interestingly, again, we see this is a form of punishment that both Abu Bakr and Ibn Zubayr and other Umayyad caliphs purportedly adopted. In his Institutes, Justinian expands the scope of the Lex Julia, a law on adultery passed in the reign of Augustus, to include the death penalty for sex between males. As of the 11th century, punishing Liwāṭ as zina became a widespread legal position in the Shafi'i and Hanbali madhabs, as well as among some Hanafis as well. So, not only were the Jews and Christians cited as part of the Sunan of the past, the Sunan Madiyah, but the Sunan of the companions and successors were heavily cited in the first centuries of Islam as well. Joseph Schacht, Harold Matsky, Scott Lucas, Wael Hala, and Christopher Melchert have all shown this to varying extents. Or, as Schacht puts it, 2 generations before Shafi'i, reference to tradition from companions and successors was the rule, and traditions from the Prophet himself the exception. And it was left to Shafi'i to make the exception his principle. As we can see, and I will not go through all of this because it will be very time consuming, but what you can find here is that every single one of these, and I go through each of these companions or successors and highlight all of the reports or many of the reports that are attributed to them. But what you'll find is that they're attributed with conflicting opinions, every single one of them, right? So Abu Bakr is attributed with commanding a punishment of burning, but you also find in other reports that he's advising this stoning of being pushed off of a cliff and followed by stone casting. Omar, interestingly, is attributed with an unconditional death penalty, but even more sort of on the opposing side, also reports of communal ostracism, so no death penalty at all, right? Someone like Ibrahim al-Nakhai, who is a well-known scholar, is attributed with 3 conflicting opinions, all 3 legal positions that are attributed to legal jurists in the period that follows. So, and you can go through this and look at this. And it's not only the companions and successors who are attributing with these conflicting legal opinions. You also find that the eponyms of 2 schools of law, right, Imam al-Shafi'i and Ahmad ibn Hanbal, as well as some early caliphs, are also attributed with conflicting opinions. However, with those scholars, what you end up finding is that they're sequential, right? That they hold a certain opinion and then they rescind it and change their mind and tell us that they hold the other opinion now. So with them, at the very least, we know that it was a change of opinion, change of ideas, whereas with the earlier companions, what you find is that there's almost a want to claim them as authoritative figures to justify one's own personal legal position. As we can glean from the brief list of conflicting positions attributed to each of these companions and successors, there was clear disagreements over not only the form of punishment, right, execution by burning, stoning, the sword, but also the gradation of punishment, had versus ta'zir, and so on. Amongst these early companions and successors, which is a far cry from this purported definitive companion consensus on execution as the form of punishment. So again, the question arises, why, right? Why cite the precedent set by the earliest generations of pious authorities on this matter as opposed to the Prophet's own precedent? I'm not going to get into this in detail in this paper, but I do this in the larger project where I show that there was indeed an absence of prophetic legal hadiths on this issue that were at the very least viewed as authentically tracing back to the Prophet himself. And the Quranic law narrative was also not read in the same way as it was read by later exegetes of late 4th, 10th century. So take, for example, I just want to offer 4 early legal texts that represent what we have come to know as the Maliki madhabs, the Shafi'i madhabs, and the Hanafi madhab. So what you'll see here is none of these jurists point to prophetic hadiths as justification for their legal position, and they don't cite Quranic textual evidence or verses to support their arguments. Even a Shafi'i, right, who is a leading proponent of traditionalism, is not associated with invoking the unconditional death penalty hadith to support his initial unconditional death penalty position, nor the conditional death penalty hadith to support his second position after having rescinded the first. Instead, he cites the authority of Imam Ali and the Sunnah, whatever Sunnah that is, and invokes these to support his initial position, and then he doesn't invoke any other supporting evidence for the second position. He states it. So it's only during the 4th or 10th century that we begin to see jurists fully incorporating prophetic hadiths in their legal texts, and these are prophetic hadiths on Liwāṭ, legal hadiths on Liwāṭ, to support their legal position. So I just wanted to offer only one example, and there are many more. I just wanted to give you one sense of one. This is Abu Bakr ibn al-Mundhir, who seems to be the earliest jurist to include both Quranic and hadith citations in his al-Awsat to support his position of an unconditional death penalty through stoning. And he also adds other forms of reasoning. So you have that. You also have Imam Ali and Ibn Abbas and some early jurists that are cited as supporting his position. And then he goes on to give further reasoning of why he thinks this is the position to take. Liwāṭ being graver than zina, a claim that Ibn Abbas's unconditional execution hadith, which is attributed to the Prophet, is in line with his own personal legal position, right? That it reflects Ibn Abbas's actual position. And then the fact that both Liwāṭ and zina share a common meaning of penetration, ilaj, of a sexual orifice of the farj. So interestingly, we don't see an appeal to qiyas until the 10th or the late 10th, early 11th centuries. Prior to this, however, we find an absence of Liwāṭ vis-a-vis qiyas in early usul al-fiqh texts. Of course, once some jurists began to appeal to qiyas, a debate arose over the exercise of qiyas in determining the punishment for Liwāṭ. At the heart of this debate is the fact that the effective cause or the illah of the original case, the asl, is sometimes but not always specified in the scriptural sources. So when the illah is neither stated nor alluded to in the text, the only way to identify the cause of the original case is through ijtihad or considered judgment. This means that in such cases, a jurist may extend the law of the original case to the new case on the basis of the corresponding value in his eyes. Sorry, this is getting a bit technical, getting us into the space of qiyas, but this is an usul al-fiqh panel after all. So, all right, but it is not necessary that the equality and correspondence which he takes into account in his opinion between the two cases is real. So, in fact, it can be disputed and therefore not binding on others. So determining the illah, or the effective cause of such cases, is actually subjective. In sum, in order for qiyas to be valid, it must be founded on an establishing rule based on the Quran or Sunnah. Some others also included ijma' as part of that. However, since establishing whether the cause in two cases is largely a matter of opinion, some jurists question the validity of qiyas. Their concerns revolved around the measure of juristic speculation involved in determining the causes and objectives of divine injunctions. Such juristic claims claimed that qiyas contained the possibility of error and doubt since it is speculative, zanni. They argued that qiyas cannot be used to establish a had punishment and claimed that their argument is supported by the Prophet's statement, avoid imposing hudud and other sanctions when beset by doubt. Idra'ul hudud bil-shubuhat, and this is a whole book. You could look at Intisar Rab's book on this. So, in essence, in the case of Liwāṭ, two main questions largely guided the debate over the exercise of qiyas in determining punishments. One is the application of qiyas in lexical questions valid? And two, can causality, the asbab, be extended to another case to establish a like cause or condition for a similar case? Jurists generally took one of two sides. The proponents of qiyas, which include some Hanafi jurists, along with many jurists of the Shafi'i, Hanbali, and Maliki madhabs, held that the had for zina should be extended to Liwāṭ. And the opponents of qiyas, however, which include the majority of Hanafis and Zahiris, and some Shafi'i jurists held that the had punishment for zina should not be extended to liwāṭ. So really quickly for the first question, the lexical question, jurists debated whether it's possible to apply the noun zani, fornicator or adulterer, to the noun luti, one who engages in male-male anal intercourse. The proponents of qiyas contended that both nouns share the common quality, wasf mushtarak, of penetration, ilaj. Furthermore, the Quran refers to both zina and liwāṭ as fahisha, right, tawava in the biblical tradition, and therefore qiyas should be extended between the two cases. Whereas the opponents of qiyas refuted this, whereas the opponents of qiyas refuted this by stating that since specific Arabic words were used by Arabs for a particular action, qiyas cannot be employed to prove the name of something else. So you don't call liwāṭ zina and we don't call zina liwāṭ. They're not interchangeable. And if the Arabs had two words for two different acts, we have to treat them as two different acts and not lump them together as a single semantic word. Okay, as for the second question, and this is how it looks if you're applying these pillars of qiyas and making this sort of analogical reasoning between the two cases. One is arguing for the application of it, the other one is arguing for the non-application of it, which would lead to a non-had punishment, a discretionary, juristic discretionary punishment, the ta'zir. Okay, so the second question, and I'm coming to an end, I promise, is whether the causality, the sabab of zina can be extended to liwāṭ. It's important to pause and emphasize that the hermeneutical legal debate here are embedded in jurists' conceptions of and conceptualizations, their own understanding of sex, the body, and desire, which shape their hermeneutics of qiyas. The proponents of qiyas maintain that the analogy between zina and liwāṭ is permitted. They argue that the underlying reason for extending the had punishment of zina to liwāṭ is the fact that liwāṭ is also phallic penetration, ilaj, of an orifice that is naturally desirable, mushtaha tab'an. This is where the natural philosophical language starts to infiltrate of tab', right, this nature, what is natural, and therefore and is legally prohibited. So they insist that the vulva and the anus are both orifices that could be penetrated, both lead to ejaculation and sexual gratification, both legally require concealment, and that both are naturally desirable, mushtaha tab'an, and share the same physical characteristics. This gets very graphic, such as warmth and softness, to such an extent that it is difficult to distinguish between the two orifices. In sum, according to the proponents, since the common quality, the wasf mushtarak, of penetration exists in both cases, the hikmah may be reproduced and the had punishment of zina may be extended to liwāṭ. The opponents of qiyas, however, reject the analogical extension of causality in this case, reasoning that the analogy of liwāṭ to zina is not based on some common ground, ma'na mushtarak. Unlike zina, which is phallic penetration of an orifice, the vulva, which is naturally desirable, mushtaha tab'an, and legally prohibited, liwāṭ is penetration of an orifice, the anus, that is naturally undesirable. So this is where their own sort of understanding of desire, what is desirable and not desirable, comes in. Indeed, God created human nature to shun it, for it is like intercourse with corpse or an animal, right? So this is the comparison that they draw. All right, I'm done with the legal qiyas technical stuff. While I find the debate over the use of qiyas fascinating, I have been drawn to what these texts in a highly technical field might tell us about social history and the presuppositions that shape the making of law. While qiyas is admittedly a rationalist doctrine, it nonetheless contains an element of uncertainty, which has led the ulama of all juristic schools to rank it as speculative evidence. The result of qiyas in most cases only amounts to probability, meaning it is probable but not certain that the result of qiyas is in conformity with the intentions of the lawgiver. This is with certain exceptions. But qiyas in general can never be as high in authority as the nas or definitive ijma' consensus. So having said that, I just want to make a quick case for the benefits of reading these texts, even technical texts, not only to extract the logic of legal reasoning, but additionally to try and understand the types of juristic attitudes or presumptions that shape the way jurists produced law. In this case, it's clear that juristic conceptions of sex, the body, nature, and desire absolutely shape their hermeneutics of qiyas. and its parameters, and resulted in the difference between a death penalty ruling or a few lashes as a form of disciplining for the offenders who engage in liwāṭ. And as we have seen, Muslims have historically attempted to invest their doctrinal positions with different authoritative means. Depending on the time period, jurists appeal to different sources or legal tools to support their competing legal positions. By the 10th to 11th centuries, when they came to the realization that they did not have sufficient nas support for their legal arguments, they turned to qiyas and eventually to claims of ijma' to support their competing legal positions. Yet, the purported companion consensus regarding execution as the punishment for those who engage in liwāṭ seems to have dominated beyond the 5th or 11th century that I have shown here. While Muslims have engaged in lively debates, disagreements, and disputations over liwāṭ punishments and appealed to different sources and legal tools to make a case for their preferred legal position, many today can't seem to see past the claims of companion consensus made by later jurists, and they instead choose to shut down any debate on this issue. And this is just my final slide. This is a modern, there was a statement that was put out in May in the United States by leading Muslim community members. And part of the statement makes this appeal to 14 centuries of consensus, which I hope I've shown is not really historically tenable, at least prior to the 5th, 11th century. So I just wanted to put that up for us to reflect on. Thank you.
Thank you so much. That was wonderful. If you have any questions, yes.
Thank you very much, Sara, for your very comprehensive presentation on this topic. And I'm lucky to have your presentation today because I'm going to speak about the use of analogy on the case of liwāṭ tomorrow. So it's somehow fitting. I have two questions to you. The first one is, would you limit the use of logical reasoning to the juristic discourse on the use of analogy in the case of liwāṭ? Because you've showed us very well the different narrations attributed to the companions, to the traditions, where we see different opinions, how we deal with liwāṭ. So would you say that by having these different narrations, we can expose them, but that doesn't render it like logical reasoning in this narrow sense? So would you say that the logical reasoning, the legal reasoning, applies limitedly to the discourse of Muslim jurists or not? I would be happy to hear your opinion on that. The second question is, how can we explain that the rationalists, the Hanafis, who were the ones who were known for their extensive use of analogy, limiting analogy in hudud punishments, specifically in the example you've shown here? And how would you justify the Shafi'i, who are the Ash'aris, who stick to the text, allowing analogy, extending analogy to cases like liwāṭ, and how can we justify this? I would be interested to hear your answer on this. Thank you.
Thank you so much for these very difficult questions. I appreciate them. As for your first question, if I understood it correctly, I do, in terms of legal reasoning, what I focus on is qiyas in usul al-fiqh text. So it is limited in that sense. I haven't seen, besides sort of popular Muslim preachers referring to, making statements like these, right? Like zina is so bad, therefore liwāṭ has to be even worse. And so sort of making popular sort of references in terms of analogy, but it is a technical term and it is a technical field. And I would say the argument is very much within those confines, and you'll find it in usul fiqh texts. You'll find some references in furu'a, and they make references to, especially 11th century onwards, to qiyas, or even informally to this analogy between the two. As for making sense of the Hanafis as opposed to the Shafi'is, I think at the end of the day it comes down to the Hanafis had a really hard time with, as far as what I gather on this topic, they had a hard time with justifying a death penalty without having a nas, and not only a nas, because it's not just the Hanafis, it's also Ibn Hazm, right? Ibn Hazm is one of the major sort of leading proponents of this, where he makes a case that we don't have the nusus. If you don't have the nusus, you can't make a case to kill someone on the basis of no nusus. And he can't. They did, but not in hudud. They did, but not in hudud. So the Hanafis, so if you look at Sarakhsi, for example, he says, we don't accept it when it comes to hudud. Yeah, I mean, I can only guess, and I think, I mean, part of it, again, is this discomfort with, if we don't have the sources to prove it, and it actually comes down to this linguistic distinction that they made, right, where it's a very, like, slight hermeneutical distinction, where they say, zina is not this, the Arabs themselves don't use zina and liwāṭ interchangeably. So linguistically, you can't even justify it, right? So it's just a lexical analogy. You can't make this type of lexical analogy to say that both are the same thing, because we know that Arabs don't use them interchangeably. So the Hanafis, in the end, ultimately make a case, especially if you look at Sarakhsi, he attributes Abu Hanifa with making this hermeneutical sort of argument, semantic argument, that it's not a lexical, you can't make that lexical extension. And for the Shafi'is, they're willing to make the lexical extension, and they're comfortable with it, and they go with it. But I think in the end, it was only a means to justify an existing legal position that they've already held. So as I said, I mean, this is a position that already pre-existed Imam al-Shafi'i, and there were debates about them. And so how do we justify this position? Well, let's look at the Sunnah Madiyah of the Jews and the Christians. No, let's look at the companions and the successors. No, we could use actually qiyas. Actually, forget all that. Let's talk about ijma', right? So it's really sort of drawing at these straws, trying to make a case for how can we justify this? Well, there are different ways, there are different means of legal reasoning. This is what I prefer in this century. No, now that we've gotten to this point in usul al-fiqh, let's use qiyas. No, let's use ijma'. And so you have different sort of ways of drawing on different authoritative means to justify one's legal position. But ultimately, it's a justification for an existing position. It's just a matter of making it accepted. Yeah.
Thank you.
Yeah.
Thank you very much for the paper. I really enjoyed it greatly. I wanted to mention a couple of parallels to Jewish tradition and then raise a question, if that's okay. So first, the parallel. So fascinatingly, the Talmud also has this comparison between male intercourse and male-female intercourse, and studies, it interprets that and derives all sorts of rules. And the Talmud, drawing on the verse says it's prohibited for a man to sleep with a man like with a woman. So the verse itself compares them,
Yep.
And the Talmud calls that, it says hikisha hakatuv, hikish, which is the same root, the same verb as kiyas, actually, and derives all sorts of rules there. So I don't know if that's just sort of a parallel development, or if there's a way in which somehow the analogy that also is drawn in some way from Jewish tradition, and then a different parallel. There is also a debate in Jewish law as to whether male anal sex is to be considered something that's desirable or not, with all sorts of implications, like someone who violates that law considered to be sinning out of desire or sinning out of rebellion. That would depend on that. So those are just two parallels that I find fruitful to think with. And now the question on the sort of more on the diachronic side of things, how do these ideas from the Mishnah and the Talmud, and how do they get there? Especially because these laws weren't practiced, right? The punishment for homosexual intercourse, I don't think we have any evidence was ever practiced, in the medieval period by Jewish communities. So presumably the teachings, the ideas were somehow circulating, and do we know, was it a text? Was it people? Yeah, what sort of account do you have for that?
That's an excellent question, and I'd love to talk to you afterwards about the parallels, especially the second one, which I didn't know existed. And so I am not a biblical scholar. I've studied it to some extent, but I wouldn't claim authority on that. But in terms of how it comes, that's a really good question, and it's one that I have struggled with a lot. And what I ended up deciding on is going with Muslim scholars' claims to having read these texts. Right? I have no idea if they had access to these texts, but they mention the Talmud says. And so when they tell me the Talmud says, I'm going to assume they have some sort of idea, wherever they got it from, that it says whatever they think it says at this time period. And so that essentially comes down to my own citation is, are these intermediaries, often they're converts, Wahab ibn Munabbih is often cited in this regard, where they say, the Talmud says X, and so it says. And so that's where I'm getting them from. I've had a hard time sort of trying to figure out how to locate I don't even know if it's possible to locate which texts were circulating at the time, Jewish texts. But I know the traditions are there because they're cited by Muslim scholars who are very openly and willingly saying, the Talmud says this, therefore, we take from this. And they're citing the Sunan, right? So they'll say this is a Sunnah Madiyah. Someone like a San'ani, for example, in his hadith collection, refers to the actual, like he says that Wahab ibn Munabbih was exposed to the Talmud, and in the Talmud it says this about this law on incest, and it says this law on male-male sexual intercourse, and he cites it in that way. So I'm basing it on early Muslim scholars' personal citations of whatever the Talmud meant for them, and whatever it looked like, and I have no idea what it looked like, so yeah.
Thank you.
Thank you very much.
You're welcome.
Super interesting.
Thank you.
I have a very technical question. So the illah in both qiyas refers to the action itself. Was there any attempt to talk about qiyas that refers to the agents that take place and compare it to incest or something like this rather than just to the action?
Yeah, so the incest comes in the hadith. So, and this is something that I trace the historical sort of development of the hadith and it mentions a trio, right? It mentions Liwāṭ, it mentions incest, and it mentions bestiality, which are the three that are mentioned in the Jewish tradition. And so I trace that in the hadith chapter. In the legal formation, you don't have a qiyas to age and you don't have a qiyas to incest. It's very technically based on, can you draw an analogy between two cases, and are they applicable? Age and incest are not. They're part of the consideration when it comes to should the punishment be meted out or should not. But it's not a question of can you make an analogy. It's just a question of do you punish someone? How does age factor? And that does come in, but it isn't in the question of qiyas. It's in the question of application of the law in the furu', in the juristic text. Yeah.
Do you have more questions? Okay.
Just a very simple one. Do you find similar kinds of debates in Zaydi and Imami texts?
Okay, so this is interesting because so I don't include the Imami texts in this current book project. I have looked at them. I studied with someone in Iran on this issue, and we read texts together. They have similar debates. They come out with differing opinions. Qiyas is not used. They reject it. It's not, as you already know. They're like the Hanafis and the Shafi'is. They reject it, but nonetheless, they make a case for had on other grounds. Mainly Imam Ali having punished al-Ṭūfī with a had punishment. So you find similar debates, but qiyas is not a factor because they reject it. They don't use it.
And
Zaydis I have not looked at. Yeah, only Imamis. Yeah.
Thank you. Thank you so much, sir. I appreciate it. So our second presenter is Professor Serdar Kurnaz. He's the chair of Islamic law here at the Institute for Islamic Theology, and he's also my supervisor. So yes, so we are going to hear from Professor Kurnaz.
Thank you, Amin. Hi, everyone. Welcome to that wonderful panel that Amin organized. I forced him to invite me, so I cannot thank him that he had me here. But thank you to being so kind to including also my paper. I'm going to speak about Najm al-Ṭūfī's Atomistic Argumentation for the Probative Value of istiṣḥāb al-ḥāl, and I also have to thank the next presenter, Kumail Rajani, because he asked me last year to present something on istiṣḥāb al-ḥāl from the Sunni perspective. I got through al-Ṭūfī, and I found it very interesting to present and find that link between atomism and istiṣḥāb al-ḥāl. So thank you, Kumail, for giving me the opportunity to focus on that particular question. I can do that one. Yes. So related to the conference this week, one of the main assumptions of the conference is that concepts, methodologies, texts, and theories within the intellectual tradition of Muslim scholars are not static entities transmitting unchanging ideas over time and place, but are part of dynamic exchange that constitutes and are constituted by social cultural interactions. And I want to show, or I want at least try to show, that it is also important for the whole Islamic legal tradition to contextualize different concepts of legal scholars, be it in Islamic law, furu'ul fiqh, or in Islamic legal theory. And I want to share my thoughts how we can approach the Islamic legal tradition, and which shortcomings we face when we focus only on some periods and on some texts and try to understand the whole tradition of Islamic law, as also Sara pointed out in her introduction, to which I agree. My case study today is al-Ṭūfī's understanding of istiṣḥāb al-ḥāl. To the best of my knowledge, he is the only one who who understands istiṣḥāb in terms of atomism, and istiṣḥāb. I can describe istiṣḥāb briefly as the presumption of the continuance of something, or briefly presumption of continuity. And he's the first one who explicitly argues with regard to kalām atomism in order to argue for the probative value, the hujjiyya of istiṣḥāb. Before him, there are some scholars who discuss relevant topics for kalām atomism, however, they do not mention it overtly. And I want to show that al-Ṭūfī argued with respect to kalām atomism because of his particular interest in systematic theology, and because of his sources that give him hints for such an analysis. And his sources, again, were written during a time when atomism was already established within kalām and already began losing also its impact. Therefore, my presentation is structured as follows. I want to give, first of all, an overview on kalām atomism. Then I want to focus briefly on al-Ṭūfī's biography and his work on legal theory. And then I want to present the al-Ṭūfī's interpretation of istiṣḥāb al-ḥāl. The fourth step will be the contextualization of the atomist understanding of law, and then not a conclusion, rather an outlook how we can approach the Islamic legal tradition. The overarching question of my presentation is: do we find in later sources interpretation that lead us to unchanged ideas, which could be traced back to early sources or not? And my thesis is that's the worst thing we can do to the Islamic legal tradition when we do that, when we answer that question with yes. And some do, and I want to show that leads to that misleads us how to understand the Islamic legal tradition. Coming to the kalām atomism, Muslim theologians developed approximately with the mid-3rd, the 9th century, a physical theory, or better said, a natural philosophy for describing the worldly existence. In summary, according to this theory, the world consists of substances, the so-called jawhar, jawahir, and a'yan, or ayn, and accidents, a'rād. And the smallest indivisible part in kalām atomism is the part which cannot be divided further, the so-called juz'u alladhi la yatajazza. Matter and bodies, ajsam or jism, can only exist when accidents come together with substances, and there is no agreement among theologians on the specific amount of atoms that constitutes a body. However, the majority agrees that bodies by definition must have length, breadth, and depth. Since substances and accidents are not the same, scholars differentiate them. Accidents are attributes or qualities sifat, of substances like color, smell, and movement. According to kalām atomism, accidents need to be connected to substances in order to exist, since, at least according to Ash'aris and Maturidis, they cannot overdo two consecutive moments. In every moment, they have to be created anew. Hence, all occurrences in the world are contingent, everything is initially created, and in each moment continuously recreated. And this summary gives an idea of the physical theory of Muslim theologians on which they built up their theology. They developed these core assumptions within a lively debate on different cosmological and physical theories. I cannot outline the whole development of kalām atomism among Muslim theologians, but it should be at least mentioned that the aforementioned core assumptions were influenced by different theories coming from the Greek and Indian philosophy and or the Iranian tradition. At first, kalām atomism was not widely accepted among Muslim theologians. In general, we have three main strands. We have the so-called sensualists, who said that the world exists only of bodies. We don't have the category of accidents. Secondly, we have the group of the accidentalists, for whom the world exists only of accidents. And third, we have our atomists, who are in between these two physical theories. With differences, it was widely accepted by also Mu'tazili, Ash'ari, and Maturidi scholars. Studies so far on kalām atomism show that atomism began to decline by the 6th, 12th century due to also thorough criticism of Ibn Sina, and scholars lost interest in the idea of the division between substances and accidents, or did not hold strongly to that concept, although scholars from the 8th century, the 14th century, still refer to it as a typical subject of kalām, but not building up the theory on that division or dichotomy. Although atomism began to lose its prevalent influence by the 6th century, Hijri, 6th century, we can see that scholars like al-Ṭūfī use arguments from atomism and use atomistic terminology in order to analyze the legal theoretical issue, the validity of istiṣḥāb. For him, the main discussion is whether persistence is possible within an atomistic physical theory, since istiṣḥāb is the presumption of continuity or continuous existence of something. And before dealing with this interpretation, let me briefly present who al-Ṭūfī is. He's mostly known for his understanding of maslahah, but he wrote more interesting things than only his commentary on maslahah. Al-Ṭūfī's full name is there. I don't want to quote the whole name, it's too long. He was born after 670 to 1271 near Baghdad in the village Ṭūfā, and he went through different stages of studies. In this brief summary of his studies, first he studied at the Madrasa Mustansiri in Baghdad in 691 and moved to Damascus in 704. There he studied with prominent scholars like Ibn Taymiyyah for only 1 year. He liked him very much, but did not repeat his understanding of usul al-fiqh. Later in 705, he moved to Cairo, where he worked as a mu'id, a repetitor at different madrasas. In 711, he was imprisoned and accused of being Shi'i. According to Leila Demiri, there is no clear evidence for al-Ṭūfī being Shi'i. Rather, there could be different reasons to accuse him in order to get rid of him by his colleagues in Egypt. The reasons could be competition or disrespect to other masters of law. Al-Ṭūfī was first expelled to Damascus. However, he could not enter the city because of satirical poems he directed against its inhabitants. So he had to move to Dimyat first, and eventually settled in Kūs in Upper Egypt. He left then Kūs in 714 to perform the pilgrimage in Mecca, visited Medina, and rested there for a year. After his second pilgrimage, he moved to Palestine and died in 716 in Hebron, in Kharif. So bibliographical entries describe al-Ṭūfī as a prolific author who belonged to the Hanbali school of law. He wrote in several disciplines, including Quranic exegesis, Quranic studies, dialectics, systematic theology, hadith sciences, Arabic literature, and Islamic law and legal theory. And for our case study, the main work is Sharh Mukhtasar al-Rawda. It is the commentary of the abridgment of the eminent scholar Ibn Qudama, the Rawdatul Nadir wa Junnatul Munadir. At-Ṭūfī first abridged Rawda in 704, probably in Damascus, before leaving Damascus. Later in 708, in his years in Cairo, he commented on this abridgment. The sources he used are these ones. Abu Hamid al-Ghazali, of course, because Ibn Qudama's work is an abridgment of al-Ghazali's Mustasfa. Sayfuddin al-Amidi's Muntaha al-Usul. This is a non-extant work, but an abridgment of Ihkam. And we do have Ihkam in its full length. Shihabuddin al-Qarafi's Tanqih and Sharh Tanqih al-Fusul, of course, because Shihabuddin al-Qarafi, during the time when At-Ṭūfī lived in Cairo, he was a very prominent scholar, especially these two works, Tanqih al-Fusul and Sharh Tanqih al-Fusul. And as At-Ṭūfī mentions it as well, he made use of also Fakhruddin al-Razi's Mahsul and Abu Ya'la al-Farras al-Udda. These are sources that we not detect between the lines. Rather, at the last 2 pages, At-Ṭūfī himself mentions these sources and some more further sources from Jadal, but this is not important for us for this case. These sources show a clear preference of At-Ṭūfī. He clearly situates himself in the Hanbali tradition, but follows mainly al-Ghazali's approach via Ibn Qudama. He also prefers the more somehow philosophical theological approach of al-Amidi and al-Razi concerning the question of istiṣḥāb, who are especially known for their contributions both in kalām and philosophy. At-Ṭūfī's choice for al-Qarafi underlines this as well, although al-Qarafi's works were well established in Cairo, where At-Ṭūfī wrote his commentary. Besides of other major Maliki sources, he himself, al-Qarafi himself, mainly followed the line of Razi in both his Tanqih and Sharh Tanqih al-Fusul, since he also wrote an extensive commentary, the Nafais al-Usul and Razi's Mahsul. This marks also somehow a network in which At-Ṭūfī situates himself. Hence, these sources and approaches of these scholars influenced At-Ṭūfī, of course, directly while commenting on istiṣḥāb within the frame of kalām atomism. And let us have a look on At-Ṭūfī's argumentation and his interpretation of istiṣḥāb. So, reading the Sharh, At-Ṭūfī defines istiṣḥāb as the presumption of the original or initial negation, the so-called al-nafy al-asli, of a given ruling. It is, besides the Quran, Sunnah, and consensus, ijma', the fourth source among the sources of law. He follows the line of Ibn Qudama and al-Ghazali. He describes istiṣḥāb as the general precept, al-asl, that a ruling does not exist in a specific case. Al-asl adam al-hukm fi hadhihi al-waqi'ah. He says, thus one presumes that a ruling does not exist unless there is a proof for its existence. This is nothing new. Nearly everyone defines istiṣḥāb in that way. He remarks that the majority of the scholars accept the probative value of istiṣḥāb. Hanafis and scholars like Abu Hussein al-Basri are against using istiṣḥāb within legal argumentation. This is not wrong, also not true, but I skip that aside. At-Ṭūfī underlines that istiṣḥāb can sometimes be based on a rational argument. It has 2 different types. The rational argument, like the presumption of the original state of being free of obligation. This is called istiṣḥāb al-ḥāl or al-barā al-asliyya. For At-Ṭūfī, reason affirms this state. There is no ruling for believers who are otherwise obliged to follow an existing rule if there is a reference for that or an indication. Reason, however, can only negate that there is an obligation. Affirmation, the so-called ithbat of a ruling through reason, is for At-Ṭūfī unacceptable. Since it has no capacity in this, reason has no capacity in this regard. It is, like he says, qāsir anhu. And At-Ṭūfī gives an example. Principally, the defendant is not accountable. Reason shows that the defendant has no obligation, since reason alone does not affirm a ruling when there is no evidence for any obligation. The second type, of course, is istiṣḥāb based on a revelatory evidence, like the presumption of a ruling being general, istiṣḥāb hukm al-umum, and presumption of a ruling based on consensus. So one can assume that the general statement in Quran and Sunnah refers to a general ruling as long as there is no evidence that specifies that general utterance. Ṭūfī mentions here several further types of istiṣḥāb, like istiṣḥāb al-nas, that means that one should regard a textual reference unless there is an evidence for its abrogation, or istiṣḥāb of an established verdict, istiṣḥāb hukm thabit. For example, or for instance, when someone possesses a property, then this property belongs to him unless proven otherwise. The same is true for further istiṣḥāb, like presuming the default meaning of a word unless there is an evidence for its figurative or metaphorical sense. In summary, istiṣḥāb is the assumption that something continues to exist based on the affirmation of its existence before. And according to a Ṭūfī, if we define istiṣḥāb in that way, istiṣḥāb is based on the idea of continuity. And since continuity, now it becomes interesting. Before it was like the whole tradition, as it is reported until a Ṭūfī. Continuity is an accident, it's an arat. A Ṭūfī discusses the capability of existence into consecutive moments on their own. We remember that according to the Muslim tradition, or the theological tradition, accidents cannot overdo two consecutive moments, so therefore continuous existence is impossible. So we can also not make use of istiṣḥāb. This is the basic question with which Ṭūfī deals with. Thus, Ṭūfī refers to the discussion among theologians about accidents, whether they can exist on their own or do they need something else to exist with, like motion and stillness or being black and white. Ṭūfī follows the concept that accidents have two types. Permanent self-existing accidents, he calls them qarr-dhat, we could translate it as permanent nature or permanent in nature, such as colors in general, and they come to being at a particular time. He calls it duf'atan wahidatan, and they persist. The second type is that accidents that are constantly flowing. He calls them sayyal, like temporal motions such as the movement of the planets and stars. These movements come to existence bit by bit. So Ṭūfī prefers the view that persistence as an arat is a self-existing accident, like black and white. For his decision, Ṭūfī takes recourse to rational arguments and says, if we say persistence, if we say baqa of a thing, then we mean by that the duration and continuation of its existence, istimrar wujudi. And it is, unlike motion, an attribute that is consistent and permanent. Motions, however, are constantly flowing. One can perceive their flowing, sayalanuha, and notice their absence and existence. And if persistence was the same as flowing, then it should be perceivable in the same way. And he implies that permanent existence does not exist bit by bit like motion, since we do not perceive its existence and absence in the same way as we do it for motions. So Ṭūfī now deals with a related question that results from his decision before. The question is whether something persistent is dependent to a cause. For him, it is independent from a cause, such as the color black, which is, with its attribute of being black, is with that independent from the thing that makes it black, the musawwid. All of it sounds quite complicated, but it is not. Ṭūfī concludes that istiṣḥāb al-ḥāl is based on these principles. He basically says that persistence should be argued as or perceived as something existing in itself. It is based on the concept of persistent as being a permanent existing accident, since istiṣḥāb is holding on something previously known in the sense of negation or affirmation of something. Ṭūfī underlines this is exactly what jurists mean when they say the principle is that things remain as they are. الأصل بقاء ما كان على ما كان. So now, once he said that within the frame of atomism, istiṣḥāb al-ḥāl is possible, that does not ultimately mean that we should also argue in a legal context regarding istiṣḥāb al-ḥāl. So he focused on the probative value of istiṣḥāb. And he refers here to kalām arguments as well. The kalām concepts he refers to is, he refers to a theological question and says that the necessity for proving the veracity of a person's claim to prophethood, as before him already Razi points out, one has to deal with istiṣḥāb al-ḥāl. Because for a Ṭūfī, istiṣḥāb is one of the requirements of the missions of the prophets. Considering that their mission is true, what the mission requires should be true as well. He underlines that the prophethood of prophets can only be affirmed after their performance of miracles. And miracles, however, are matters that disrupt the ordinary sequence of events, خارق العادة. And the ordinary sequence of events, though, is the constant appearance of things either continuously, under any circumstance, like the circulation of the sun and the stars in their rotation, and he refers to a Quranic verse, or from time to time, like the rise of the sun from east and the sunset in the west, or like raining in the winter and the rise of the Nile during these rainy days. And he also refers to the custom of people. He says, people act as well according to istiṣḥāb al-ḥāl. If they leave their hometown, they assume that their family and relatives continue living in that city, so that they write them letters. And they, based on the assumption that their relative who left the city continues existing, respond to these letters, based on that assumption. And why does he do that? I think al-Ṭūfī has epistemological concerns in mind. According to al-Ṭūfī, as he mentions in a subsection, which he calls faida, the principle of bara al-asliya, which is a subtype of istiṣḥāb, is at the epistemological level of certainty. And here he discusses the contradiction of the principle of istiṣḥāb with weaker sources of law, such as legal analogy, qiyas. And thus we can say that all the arguments he mentioned before, kalām arguments, within the legal context, also the arguments from kalām with regard to atomism, he tries to give the istiṣḥāb the epistemological value of certainty, since it is for him, as well as for al-Ghazali and Ibn Qudama, the fourth source of law. So he has also the epistemological boundaries in mind, which scholars drew in the legal tradition, saying that sources, the main sources, should be on the level of certainty. Now, coming to al-Ṭūfī sources, most of al-Ṭūfī sources do not refer to the principle of atomism while discussing istiṣḥāb. Other sources do not refer to them as well. The only two exceptions are al-Amidi in his al-Ihkam and probably in his Muntaha, and al-Razi in his Mahsul. From these two scholars, only al-Amidi use or refers to atomistic terminology. Al-Amidi refers to atomism as the fourth important point in order to argue for its validity. I'll skip the first three ones and have to check where the fourth one was. Here. Al-Amidi discusses the question whether persistence, although being an accident, needs a cause, as Ṭūfī did, will do later on. He says that it is not dependent on a cause, which means one can assume that something persists without the need for an evidence for its existence. In contrast to Ṭūfī, Al-Amidi does not refer to any distinctions of accidents. He only says, if you also assume that persistence is an accident, it is not a problem to assume that it can overdue two consecutive moments. And looking to al-Razi, without referring to the question of accidents, al-Razi deals with the question of persistence, which is a requirement for istiṣḥāb. The discussion is similar to Al-Amidi's work, and basically he says more or less the same al-Ṭūfī already said, as I presented already what al-Ṭūfī said. So the question now remains is, can we use the lenses or the the interpretative tools of al-Ṭūfī in order to understand the whole legal tradition from the perspective of atomism. Al-Ṭūfī's endeavor can be read as a part of his own understanding of theology and legal theory. That's nothing surprising, since he was interested in the coherence of theological and legal assumptions with the revelatory sources. He wrote more than one book on these questions. For example, his Isharat al-Ilahiyya is also dedicated to usul assumptions within kalām and usul al-fiqh, and he tries to argue for them within his Quranic exegesis. And he tries to build up a theory based on commonly accepted assumptions. However, it would be wrong to assume that al-Ṭūfī's approach could be generalized for the whole tradition of legal theory. If we compare his work to others, except of al-Amidi and al-Razi, almost no other scholar refer to atomism within the discussion of istiṣḥāb. Hence, one can easily say that it is not representative for other scholars. However, one could be tempted to generalize his, or at least al-Amidi's or al-Razi's approach, since it does fit in with the widely accepted kalām atomism in their work, and their work were widely, highly accepted and respected, al-Razi and al-Amidi. On the other hand, we know that atomism was prominent from the 5th till the 8th century in Islamic law, and it generally declined afterwards. Al-Ghazali, for instance, did not see it as an important theory, and during different stages of his scholarly endeavor, al-Razi himself sometimes accepts and rejects it. Still, there are some scholars in the 5th to the 7th century who refer to atomism also in substantive law. Now, if you look at substantive law, for instance, we find in some Hanafi works such as al-Debussi's work or al-Sarakhsi's work, which is also not a surprise because al-Sarakhsi is a huge fan of al-Debussi. We can see that they refer to accidents and substances when they discuss the validity of rental agreements. Briefly, rental agreements are for the scholars the sale of usufruct, the manfa'a, in analogy to sales contracts, where the subject matter of the contracts are existing sales item, a'yan. In contrast to them, usufruct does not exist, or usufruct do not exist in the moment of the completion of the contract. And if someone rents a house, the usufruct of housing does not exist unless one lives in that house after having signed the contract. Thus, according to the majority of scholars, Hanafi scholars at that time, the sale of non-existing items is forbidden, the ma'dum, and scholars like al-Debussi see a problem in selling the ma'dum within the realm of atomist understanding of the word. The main point here is that scholars equate the distinction of selling usufruct and real existing items with the categories of accidents and substances, and the problem of rental agreements occur because of this atomist understanding of the existence. This is only at the first glance, and some scholars, like the Turkish theologian Hasan Hacak, studied such cases, and he especially generalizes at Debussi's and some other scholars' approach and says that since the very beginning of the development of Islamic law, scholars made a distinction between usufruct and existing sales items in Islamic law, and this is due to their understanding of an atomistic world. It is true that we have a clear evidence from the very early sources that scholars make a distinction between usufruct and existing sales items as subject matter of sales contracts. We can see it in Shafi'i's al-Umm, we can see in Kitab al-Asl of Shaybani, but how they do not refer to atomism at all. Rather, scholars who overtly reject atomism, such as Abu Bakr al-Asam, who died in 200 after the Hijrah, 816, and Ibn Hazm, they accept the distinction between usufruct and real existing sale items and do not equate it with arad and jawhar, with substances and accidents. Ibn Hazm especially shows that it is forbidden to make an analogy between sales contracts and rental agreements, since their subject matter is different, selling usufruct or real existing sales items. Thus, the atomist understanding of law and the use of an atomist terminology is a phenomenon related to the 5th till the 7th century. Again, within Hanafis, scholars in later centuries avoided using atomistic argumentation although the two major scholars referred to accidents while discussing usufruct overtly, which are who are Debussy and As-Sarakhsi. Hence, one has to be cautious in reading the historical development of Islamic law and legal theory through the lenses of a particular interpretation of commonly accepted concepts, ideas, distinctions, and conventions in particular centuries. One question remains, what does all of this mean for us? Or more generally speaking, what does this mean for the research related to Islamic legal tradition? First of all, we have to read the concepts within their own historical context. We had also a very beautiful example in your talk, dear Sara. And there is much to detect in Islamic legal tradition that could be related, and that is my suggestion, to a new field that we do not have in the Islamic legal tradition, philosophy of law. Within the tradition of Islamic law, we do not have explicitly such a field, but probably usul fiqh was sufficient. Since Islamic studies and recently Islamic theology in Germany were established in the context of universities, and since at the university there are faculties such as philosophy and law schools that deal with related questions, it is for me required to interpret these approaches within philosophy of law. Doing this will enable us to find new ways for reading the history of Islamic law, interpreting it and making it accessible with a common academic or scientific language and understanding that is interdisciplinary accessible. Researchers in this field will not only allow to contribute, researchers in this field will not only allow to contribute to the history of philosophy of law, and nearly in every work that gives an overview on the philosophy of law, the Islamic tradition is underrepresented. You can only read a half a page or a page if you're lucky. On the other hand, such a field would allow us to discuss with respect to contemporary approaches to law and normativity, and reread the Islamic tradition. Further, it also takes into account our circumstances of research. We do not read legal works as pre-modern scholars read and wrote. We divide them into different parts, compare them with respect to chosen questions we have in mind, and focus only on one aspect rather than reading it entirely within a mazhab tradition. This, however, could be also an advantage, and since we are able to contextualize differing approaches and understanding and concepts. And this is my last point. In order to organize our research, to understand that we are doing, what we are doing, it is necessary to create our own field that allows to contextualize the analyzed concepts, since this is today also the common approach in philosophy of law in general, and reshape the tradition, make it accessible with regard to the also contemporary epistemological and hermeneutical frame of academia or researchers in universities. Hence, we can detect historical developments as such, we can free them from the burden of being perceived as unchangeable, and find new ways with regard to contemporary questions and approaches. Thank you.
Thank you so much, Professor Kurnaz. The next speaker is the question, so he prefers if we do both presentations and then follow them with questions. So the next speaker is Dr. Kumail Rajani, who is a lecturer at the University of Exeter, where he also received his PhD. And he's going to be talking about issues pertaining to religious authority in Indian subcontinent. Thank you.
I'd like to begin by thanking the organizers for such a beautiful workshop where we get an opportunity to learn and receive feedback on a variety of topics and the discussions. I should warn you by saying I am a misfit in this panel. The panel is about Islamic legal theory, jurisprudence, usul al-fiqh. My talk is going to be slightly different from usul al-fiqh. However, I used to work on usul al-fiqh. I continue working on usul al-fiqh. My previous project was on usul al-fiqh. I published material on usul al-fiqh. But today I'm not going to present anything about usul al-fiqh simply because I'm not funded to speak on usul al-fiqh. My current project is a British Academy Research Fellowship, a postdoctoral research fellowship, where I interrogate the question of religious identity in colonial India in 18th and 19th century. But broadly speaking, we're discussing about texts not being static entities. Sara said, Serdar, yesterday Muhammad Gharaiba. We would explore in this talk about the religious identities of a community in India who reads, interprets, appropriates Quran and many other religious texts in a certain way, which is alien to understanding of the so-called mainstream Islamic traditions. And I begin my talk from here. The Khojas are an ethno-cultural community of people originating in the northwestern provinces of Indian subcontinent. So this is the area which I'm focusing, Sindh, Gujarat, this part of Gujarat, not the entire Gujarat, so this particular belt. Up until the 19th century, they followed a syncretic tradition that was neither Hindu, due to various Islamic expressions embedded in its devotional literature, nor Islamic, as it operated particularly in legal matters according to Hindu tradition. The term Khoja was subsequently used strictly to denote their caste distinction and not their religious persuasion. 19th century colonial India, however, witnessed events that forced Khojas to self-identify with a demarcated religious identity, leaving them divided into Ismailis, Dweller, and Sunni Khojas. This paper aims to examine the creed of the early Khojas and analyze internal and external dynamics that contributed to the reshaping of their religious identity, and highlight the difference between vernacular and colonial interpretation of eclectic traditions such as Khojas. One might call Khojas as a cluster of different castes, although some scholars in the secondary literature have mentioned Khoja being a caste. I won't call Khojas as a caste, I would call it a cluster of different castes. Well, Khojas did not follow a systematic institutionalized region. I often is asked the question about what are the tenets, what are the doctrines, what are the aqaid, what are the usul of like Khojas, and I would say that's an incorrect way of thinking, because we tend to look from Abrahamic tradition, and for us these questions are relevant, but for Hindus or for Khojas, so to speak, these questions do not emerge. The tradition which they used to follow, as I said in my introduction, is neither Hindu nor Islamic. The tradition which is called Satpanth, which I would loosely translate as Saratul Mustaqim. So I contest what Faisal Devji in his unpublished paper has mentioned about Khojas, introducing Khoja is a Vaishnav Panth, a Sufi order. No, Khoja is, they are not like, it's not a Sufi order. A traders guild, that's true. And a caste, as I mentioned, Khoja is not a caste identity. As far as the devotional literature is concerned, the devotional literature adopted by Khojas is something called Ginan, which is in vernacular languages. It's hymns. There is no creed, usul, or no fiqh or literature in that work. Both Islamic and Hindu tenets, I would be cautious to use the word tenets as well. The concepts such as like das avatar. So the way this devotional literature would work is like the mention of Quran is abundant in like Ginan literature. On the other hand, like Hindu ideologies such as like there are 10 incarnations of the Hindu god Vishnu. The 9 incarnations have been already occurred. The 10th is gonna be coming in Kali Yuga, according to Hindu mythology. Now, the way Ginans would introduce is like the 10th avatar of Lord Vishnu is going to be in the form of Ali bin Abi Talib. He's going to come and spread justice, and the way it has been portrayed in Ginan, which is devotional literature. Just to quote a couple of examples, like here, Pir Shams narrates the knowledge of the Quran. A believer is one who knows the divine knowledge. So here the name Quran would appear in Ginan literature. The Sadhguru says Pir Shams has preached the Quran and preached the 4 Vedas. So here amalgamation of both Vedas as well as Quran being preached, and the knowledge of Quran and Vedas are disseminated within the Satpan tradition. Sitting among the Gad Jamaat, he has narrated the true science. I would call a back projection of what Ivanov had said. Ginan tradition had tactfully constructed a bridge between Ismailism and Hinduism. It's too soon to say or to portray Khojas in 16th, 17th century as Ismailis. Or like Daftari, in his Ismailis, he says the Pir expounded within a Hindu framework the doctrine of Imamate. So the doctrine of Imamate, Ismailism, all these words are something alien to Satpan tradition in the period which we are focusing. Yes, in 19th century, it became quite clear, as I would illustrate in a while. So research into the origins of the Khojas has gone exponentially in the last 4 decades. Nanji, Asani, Shakal, Moer, Shodan, Purohit, Boa, and others have addressed the genesis and early development of the Khoja tradition. These studies, while valuable, do not engage with the full range of available sources. Most importantly, they neglect a crucial research corpus, namely source written in Sindhi and Gujarati, the 2 principal languages of Khoja religious expression. And hence you see the word Ismailis and the word Imamate being thrown in these passages which I have just narrated. One hardly finds any reference to critical Gujarati Khoja works such as Sachidina Nanjiani's Khoja Vratan, Jafar Rahmatullah's Khoja Qawmni Itihas, and Idalji Danji Kaba's Khoja Qawmni Tawarik in the secondary literature. Nanjiani's work, for example, is particularly useful because of his access to an unusually broad range of first-hand sources in his capacity as Assistant Revenue Commissioner for the region. Research to the date has then omitted crucial evidence, the narrative witness of the Khoja people. Asani's study, for example, reiterated the conclusion of Justice Joseph Arnold without critically engaging with the method and sources with which the Khoja cases were adjudicated. We'll see a couple of examples of Khoja cases in a while. Purohit's monograph, though clearly critical of colonial understanding of religious identity, falls short of examining the cases litigated by the local judicial authorities, such as the Mahua Commission report. Unlike Arnold, who relied on Orientalist writing on Islam to adjudicate the Khoja case or Aga Khan case of Bombay in 1866, Nasarwanji Faramji, a judge appointed by the local ruler of the princely state of Bhavanagar, took sources such as burial records, memorial plaques, business ledgers, marriage invitation cards, daily rituals, along with testimonial of elderly people into consideration when adjudicating the dispute concerning the religious identity of the Khojas of Mahua. A robust study should take these full range of sources into account. My paper will redress this imbalance, studying fundamentally different lines of thought that existed among the Khojas and the colonial authorities, exploring how each was connected to a unique set of historical circumstances. On this moment onwards, I won't read my paper. I would rather prefer to go through the slide in the interest of time, because I believe we're running short of time. And the main reason is I haven't fully completed my paper yet. Okay, so let's start from here. As I said, Satpan to Sarate Mustaqim. There are 3 factors where the religious identity of Khojas is being crystallized. Number one being new norms of religious identities are coming into play after 1857 rebellion in India. The second, there are dissenting voices. And the third is Aga Khan's arrival in 1840s in India. So all these three factors are contributing how that Satpan tradition, which is amalgamation of like Hindu and Islamic identity, is diluted and like, you know, is evolved into something which one might call Sarat-e-Mustaqim. I mean, translations are same. Satpant in the Hindi, Sindhi, Gujarati tradition, Sat is like true, genuine. Panth is like Sarat, is the path. So it's Sarat-e-Mustaqim. Our sources are something which we have from 1866 and 1853. So these are British judges who litigated a couple of cases, and let me go through three cases and how the colonial interpretation is changing over a period of time as well. So number one, the case is of like a case of inheritance within the Khoja community. The case is from 1847. Plaintiff is someone called Hirbai. The way how it would work is like two women. Let me explain, like, you know, why this would be an important case for the British and why they would face challenges in terms of adjudicating. So if these daughters are Hindus, then they won't inherit according to Hindu laws. If these daughters are considered to be Muslims, then they would inherit based on what Quran would say. So how British judge would explain about like Khojas? Are they Hindus? Then their daughters won't inherit. If they're Muslims, they won't inherit. Right? So here we get the quote from Habib Ibrahim, who would say, some say we the Khojas are Sunnis and others say we are Shias. Our religion is a different religion. Aga Khan is esteemed as a great man among us. So within the community, it's not clear who they are. About the second case, which is Jamaat Khana's property, Jamaat Khana is equivalent to one might call like mosque or a community center where they would congregate and devote their time in devotional literature, reciting devotional literature. So here you see the property, the dispute is about property. The plaintiff would say property belongs to the Jamaat, the center of the community, where the defendant would say property belongs to the Imam. And now it is a period when Aga Khan, so the current Aga Khan is the 49th Imam of Nizari Ismailis, and this Aga Khan which I am saying is Aga Khan first, 46th Imam of the Nizari Ismailis. So now he's in Bombay, in India. So Judge Perry, his verdict was this, that the laws relating to the application of Muhammadan law erroneously classified that the population of India might be classified under the great heads of Muhammadan and Gento. Gentos are like Hindus, Muhammadan are like Muslim. So erroneously, so still it's not clear like where these Khojas would be fit. But in 1866, when the Aga Khan first has already arrived in India, he has established his connection with British judges and like, you know, colonial authorities. He had already paid his service in Kandahar in Afghanistan before he left from Iran. Now Arnold's verdict is completely different about Khoja community. So this is a landmark case. Tina Purohit has a monograph on this particular case. And Arnold's verdict was this. It is a sect of people whose ancestors were Hindu in origin, which was converted to and has throughout abided in the faith of the Shia Imami Ismailis, and which has always been and still is bound by ties of spiritual allegiance to the hereditary Imams of the Ismailis. I mean, this would be completely alien to the 400 years of Satpan tradition, how they existed and how they operated within the community. And this case is landmark because this is resulting in the bifurcation of Khojas into some being Hindus, still they exist, and others being Muslims. And among Muslims, some became Sunnis, others became Shias. Among Shias, some became Ismailis and others became 12 and Isna Asharis. Right, because of this particular verdict of Judge Arnold. So that was the first. As I said, like three main factors. So one is like British interpretation of like religious identity. The second is the dissenting voices. So among the community, there were dissenting voices. Now the community is migrating from the interior parts of like Sindh, Kutch, Kathiawar of the region which I showed in the map, and now they are relocating themselves into urban places such as Bombay and Karachi, two port cities in 19th century of India. So when they're exposed to the urban religious landscapes of different communities in Bombay, they started being oriented towards a new understanding about religion and religious identity. So apparently there were dissenting voices over here. I argue in my paper that the contention was not about religious doctrine. Most of the Khoja cases were about inheritance, assets of the community, and so on and so forth. It was not just like who should be the imam. If the religious authority of imam was under the question, it wasn't through theological dimension. It was due to the ambit and the scope of the imam, how much the Aga Khan should be able to exercise his rights on different assets. And when I say assets, it's not just like buildings. Sometimes the dispute was about the utensils which they were using in the community centers. So about the control over the community. We need to remember it wasn't just Bombay, although Bombay being the epicenter, it was equally in the remote areas such as Mahua, Amreli, Junagadh, and other places as well. One example, and I won't go through it in detail, but this is of Mahua Commission, which I mentioned in my introduction. Interestingly, when you see Joseph Arnold sitting in Bombay adjudicating cases, he would use the Creed of Assassins. He would use German, French literature about Islam. He would say in his works, well, the Church of England operates in this way. We have Protestant, we have a Catholic. So he's understanding the whole thing through those lenses, as it's mentioned in his work of 1866. Whereas here, Nasarwanji Faramji, a Parsi, a Zoroastrian judge appointed by the princely state of Bhavnagar in interior places in Gujarat, when he visits, he doesn't look about this Orientalist sources. He is interested in business leisures. He is interested in marital printing cards. He's holding interviews with community leaders. He's visiting the graves to read the gravestones and so on and so forth. And for that reason, when you compare, in my another article, I'm comparing both these cases, you find fascinating results, how different lenses of looking at things would result into different understanding and different interpretation. And the dissenting voice, I'm focusing on Bombay, but we need to remember Karachi was equally prominent as well. However, comparing Bombay and Karachi, the nature of disputes were slightly different. In Bombay, as I said, it was more of like community, assets, authority, but here it's more about theological voices as well. Jafar Faddu Badakshi case, for instance, in which Aga Khan is introduced as a peer, not an imam. So peer is someone who is like venerated. A Sayyid, for example, a Sharif or a Naqib, for example, but not an imam. Teaching of the Quran was discouraged by the Aga Khans in Karachi communities among the Khojas. Aga Khan abandoned the ancestral rights of the Khojas. This was something propagated by the Khojas of Pirahi Jamaat of Karachi. And Aga Khan forbade the procession of the tabuts as well. Interestingly, let me tell what I wanted to tell in this slide. So the third area which is resulting into crystallization of the community is Aga Khan's arrival in India. So for those who are not familiar, Aga Khan revolts in Hamid Alga has a paper on this about Aga Khan's revolt in 1840. From 40s onwards, Aga Khan develops excellent relationship with the British colonial authorities. As I said, because of his services in Kandahar and other places, Eventually, he settles from 1848 in December. Mind you, the first case of, third case of Sir Joseph Arnold was adjudicated in 1866. So there was a time of like almost 20 years to build that relation with colonial authorities. I'm not trying to say like he influenced British authorities, but one could connect dots how he was influential in terms of claiming that authority in Bombay among the Khoja communities as well as in parts of Gujarat as well. So Aga Khan or Ayatullah. So after Aga Khan's arrival, and like we now are aware of like what's happening in Bombay of 1866 onwards, the choice of Khoja communities, Shia Khoja communities, was to select an Imam, which was Nizari Ismail Imam Aga Khan first, or an Ayatullah of like Twala Shia authority. So some of them visited Karbala and met someone called Ayatullah Zainul Abidin Mazandarani under the leadership of Mullah Qadir Hussain, a local sort of mullah in Bombay, and they were influenced by the authority of Ayatullah Zainul Abidin Mazandarani, and a faction of Khojas converted to Twala Shiism, whereas others, I would use the word, they converted to Ismailism, because I contest the notion of them being Ismailis from beginning. So this is a period where from 1866 the bifurcation is had. This is Mughal Masjid, where the main dispute used to occur, a beautiful building in Bombay, in Dogri area. As far as religious landscape of Bombay is concerned, this is important for us to study, because the choice of Khoja communities of like Bombay between Ayatullah and Imam was not just Ayatullah and Imam, because there were other issues as well. So Sunnis in Dogri area, they were quite prominent. So some of them, their population is roughly today like between 8,000 to 10,000 people. They converted to Sunnism. Rest of them were Shiites. Shiites were under the, Twala Shiites were under the influence of Mullah Qadir Hussain, Ayatollah Zainul Abidin Mazandarani. But at the same time, very interestingly, Bombay was a place, especially the Mughal Masjid, where the ideas of Babis, Kashfis, Ruknis, Kirmanis, so on and so forth were quite there as well. So I would read from Mullah Qadir Hussain's memoir, and he takes names of like certain works of he's not quite aware of like these texts belongs to whom, but he bundles all these texts and mentions like Shahzyar Jami Kabira, Dalilul Mutahayyirin, Irshadul Awam, Sharh Khudwatu Tanjiya, Hadikatul Sultaniya. So he bundles all these texts as like, of Sheikh Ahmad Asai. It's quite clear, like Dalilul Mutahayyirin is Kazim Rashdi, and like Irshadul Awam from Kirmani, Shahzyar Jami Kabir is from Sheikh Ahmad Ahsai. I remember back in Qom, this book wasn't sold. You need to find an interior place to find where you could get hold of these 4 volumes, Shahzyar Jami Kabir. Well, now things have changed. So this was a hot place where all these things were debated. And because of the Iraqi influence and Karbala and Najaf influence, Khojas were inclined towards Twala Shiism as opposed to having Kashfi and Rukni tendencies. And of course, there was Aga Khan in Bombay as well, and certain faction, majority of them inclined to Aga Khan. I won't go towards all the shaky tendency of Mughal Masjids in the interest of time. Those who are interested in the shaky tendencies of like Mughal Masjid, one could refer to shaky literature, although Professor Rizvi always says work needs to be done about shakis in India, rightly so. So my conclusions are as follows. What I'm doing in this paper is I'm bringing new sources to light, particularly Gujarati and Sindhi sources, because I believe bringing them changes the way we are looking at the material and about certain cases adjudicated in Bombay, mainly Sir Joseph Arnold. As far as the religious authority is concerned, the community, the issues needs to be focused more from a socio-communal aspects about community assets as opposed to the doctrinal focus or about the imamate and the religious authority of the Aga Khan. The role of Bombay needs to be studied quite importantly, which I aspire to do in my paper. The problematic claims which I'm mentioning in this, I mean problematic claims, not my claims, I mean claims which are made and I find them problematic, are as follows. The claim of Aga Khan that early Khojas were Ismailis, I consider that to be problematic. The claim of Isna Asharis claiming that Khojas were Isna Asharis is equally problematic. I mean, there are a wealth of polemical works both between Isna Asharis and the Aga Khanis about they were Ismailis, they were Isna Asharis from day one, which I found it problematic. What I say is the Satpant tradition transcends the Ismaili Isna Ashari bifurcation. Thank you.
Thank you so much, Kumail. So we'll start with questions with Professor Rizvi.
Hi, thank you both for your papers. I had a question for Serdar. Well, first a comment. I mean, it seems towards the end you were suggesting, which I would kind of agree with, that we need to have a far more holistic reading of texts, and even to a certain extent the classic bifurcation of maqulat and manqulat doesn't really hold. One example which immediately comes to mind, something I've done recently, is Mir Zahid, the 17th century Indian glossator, in his glosses on logic, consistently refers to kalām and usul arguments as examples of logical forms. So that's just one very simple example of that. On this question of istiṣḥāb and atomism, so one question which I was wondering about is that with respect to the permanent entities or accidents, where is God's agency? I mean, it sounds like quite a neat argument actually to say that istiṣḥāb works because atoms do not endure, but of course God's agency sustains it, and this is why. So the reason why istiṣḥāb holds is because God exists, and that's a good argument. So I'm wondering if that's really the argument.
Thank you first of all for the first for the example you mentioned, and the second questions. Yes, good question. I don't have any answer to that because there is no one relating istiṣḥāb to that particular question within the agency of God and relating it to accidents and substances. So basically, I would argue the same way you did in order to see istiṣḥāb in the way to say that in each moment, God should have created the thing in you in order to presume that it is persistence. So the argument of al-Ṭūfī is also in terms of atomism a deviation in terms of there is no other scholar I have read so far, and that's not much, who makes a distinction between qaru dhat and sayalanu dhat. So his distinction also arad, giving the possibility to persist, is also a huge problem. The other scholars, I can imagine that they have this question in mind, do not relate istiṣḥāb at all to questions of kalām. They say we look from a law-oriented perspective and say, okay, be it as it may, we look, for example, as Rajani does that, they say we do not argue according to haqā'iq al-aqliyya, rather than we argue according to the ada, he says, I think. And he means with that the reality we perceive as it is, and the law-oriented approach to say, okay, be it as it may, I can assume that there was a verdict, and I can assume that it does exist until the other way around is proven. So this is also a type of argumentation like the argumentum a contrario. It's like dalil al-khitab extended, and I assume that the problem the Hanafis have with istiṣḥāb is totally related to the question of dalil al-khitab. So basically what you are saying is correct. I would also argue in that way, but no one deals with that problem because Ṭūfī is the one who raises that issue and no one other does. I hope that answers the question.
Yeah, thank you very much. My question goes to Serdar also. Yes, Serdar, we know from the Hanafi tradition that, for instance, Ad-Dabusi accepted effective causes that don't have original cases in the authoritative sources. And he was accused of just being not practical because it's really very hard to find causes that are effective that are not to be found in the authoritative sources. Now, after understanding from you about istiṣḥāb al-ḥāl, which is also like a rational method, which can be established independent of the authoritative sources, how far would be the same criticism which is posed against the Hanafis, especially from the Shafi'i side, would be the same on istiṣḥāb al-ḥāl by al-Ṭūfī or by the Hanbali, in terms of that we don't have enough cases where istiṣḥāb al-ḥāl is determined rationally, and this might restrict the jurists in their legal determinations of legal cases. I'm not sure if this would apply also to istiṣḥāb al-ḥāl. This is why I ask you.
Thank you. No, it is not directly applicable to istiṣḥāb al-ḥāl, what you've said already, but the core point is also in Ṭūfī's understanding, istiṣḥāb al-ḥāl you can only use to negate new rights or a change of the status quo. So you are not basically using a rational argument and making find an effective cause for legal reasoning. Rather, you say we cannot change the status quo because we do not have any clue for that. So we can also have a verdict. So we can rule accordingly. But on the other hand, he says you are not allowed to do, as Hanafis do as well. You are not allowed to do by assuming a status that you say, okay, I affirm new rights. Such as if you say there is someone missing and someone died of his family, and if there is a question of inheritance, you are not allowed to give him his rights or his portion of the, I call it portion of the inheritance. He is not allowed to receive that because then you would affirm a right according to istiṣḥāb. Ṭūfī negates that, Hanafis do as well. Shafis are in between of, they are divided into two groups who affirm or negate, arguing accordingly.
Any more questions? I have two questions for Kumail.
Thanks.
The first one is, you mentioned that Aga Khan prohibited the reading of the Quran in one of your slides. You mentioned that. What was the reason for doing so?
Yeah, in reference to the prohibition, no, I didn't mean to say that he prohibited, although that's true later on, but like the picture is quite complex as far as the first Aga Khan is concerned, because in his memoir, which is recently published, he is portrayed as someone who is, practicing in terms of like praying, making wudu and all sort of like, Islamic rituals. Even like in Mumbai, as far as Shia practices are concerned, he used to attend majalis and like that was quite a normal practice. In fact, in 1905, there is another case. Some of the family members within the royal family, they started a case, litigated case against Aga Khan, saying, well, we used to practice all these beliefs, and why you have abandoned those practices? So as the community started shrinking and becoming more and more sort of Ismailis, that sort of things came into play, of like, not imitating or not being close to Isna Ashari. So they are attending majalis, other people shouldn't be attending majalis. They are having like prayers, so here we don't have prayer. but I don't find any reference to the abandonment of, like, abandoning of the Quran, reading of the Quran. The mention of Quran is there in Ginans, but Satpan tradition as well as Ismailis today, Ismailis of Indian subcontinent, Quran is not a living text among them.
Mm-hmm. And my second question is, from the 19th century onward, is there a change in the way that the Hindus perceive the Khojas or not?
Oh, very interesting. As far as Khojas are concerned, so I should clarify that the Aga Khanis from Badakhshan or Tajikistan or Iran are different from Aga Khanis of India. So Aga Khanis of India and Pakistan, we call them Khojas. And in terms of Hindus portraying them, there has not been any changes in terms of how they are perceived. All these events which we just mentioned is something seen within the communities. As far as Hindus are concerned, Khojas won't be named as Muslims. I have grown up listening, and to this date, Sunnis and Shias are clear, right? Shias, 12 are Shia. But as far as Afghani Shias, Ismailis, they are simply called Khojas. And it's quite telling, right? They are not classified as Muslims. Not classified in terms of Hindu populace. So yes, that hasn't been changed.
So the categories that you mentioned were mostly introduced by the British, starting from the 19th century, did not have an impact on the ways that the Hindus conceptualize non-Hindus.
Oh, that's again quite interesting. So we need to look from two different angles. As far as legal matter is concerned, yes, 1866 made a huge impact. They are considered to be Ismailis, right? And Muslims, Shia Ismaili. I got an impression from your previous questions when you say Hindus, I thought you meant the Hindu community. In terms of from their point of view, they are still called Khojas and not Muslims. But as far as legal cases are concerned, they would be adjudicated as Muslims, Shia Muslims.
Do you have a question, sir?
I just had a question for Serdar. A couple, actually, if they're not based on the content. I'm just curious, why Ṭūfī? Again, it may be. I'm just curious what went into sort of choosing Ṭūfī on this as opposed to others.
It was a coincidence. I had a guess that probably Ṭūfī will be someone who has a crazy idea, and it worked out, basically.
Okay.